The delete trap. Why wiping your hard drive during a divorce can blow up your case. One of the biggest mistakes people make when divorce litigation becomes foreseeable is panicking and trying to clean up their digital life. Somebody realizes that there are embarrassing text messages, dating app activity, hidden spending, pornography, angry emails, cryptocurrency transactions, or evidence that contradicts the image they plan to present to the court. And they decide the solution is deletion. They wipe a hard drive. They delete texts. They factory reset a phone. They think they are solving the problem. In reality, they are often creating a much bigger one. Here is what many people do not understand. The attempt to destroy evidence is frequently worse than the evidence itself. Judges understand adultery. Judges understand financial mistakes, anger, addiction, and marital dysfunction. What judges usually do not tolerate well is intentional dishonesty during litigation. And under Utah law, the duty to preserve evidence often begins earlier than people realize. You do not need to wait until a judge signs an order telling you to preserve evidence. If divorce litigation is reasonably foreseeable, courts expect parties to preserve potentially relevant information. That can happen after separation, after threats of divorce, or even after serious marital conflict clearly points toward litigation. Once that happens, phones, laptops, cloud accounts, emails, and social media may all contain evidence. Intentionally destroying that information is what lawyers call spoliation of evidence. Utah's divorce rules place heavy emphasis on disclosure and transparency. Under Utah Rules of Civil Procedure 26 and 26.1, parties have affirmative obligations to disclose relevant evidence and financial information. Rule 37 gives courts broad authority to punish discovery misconduct. That can include attorney fee awards, contempt findings, exclusion of evidence, restrictions on claims or defenses, and adverse inferences. That last one matters. An adverse inference means the court may assume the destroyed evidence would have been harmful to the person who destroyed it. If financial records vanish, the court may become more willing to believe hidden assets actually exist. If parenting communications disappear, the court may infer those communications were damaging. Even if the deleted evidence cannot be fully recovered, the destruction itself becomes evidence, and most people are not nearly as stealthy as they think they are. Modern forensic experts can often recover deleted files, identify wiping software, and determine when deletion events occurred. Nothing looks suspicious to a judge like a hard drive mysteriously wiped right after separation or right after a divorce petition gets filed. People who think they are being clever often end up spending enormous amounts of money proving they tried to hide something. So here is the practical advice. If there is damaging information on your devices, tell your lawyer immediately. Good lawyers deal with bad facts every day. What becomes extraordinarily difficult is defending somebody who destroyed evidence while expecting the court to trust him afterward. Panic and concealment are what usually turn bad facts into disastrous ones.